Welcome to the Criminal Law Video Presentation Series. This is video presentation 13, and this video will cover defenses. We're going to cover a number of defenses here, and over the next period of time you might want to go through these individually, and therefore I have spaced them out and separated them with a title page. The defenses we're going to cover are self-defense, duress and necessity, intoxication, and insanity. We're going to begin with self-defense. Self-defense is really divided into two different areas. The first that we're going to talk about is the use of non-deadly force. This is just slight force or some force that will not cause significant injury in defending oneself. The elements here are the non-aggressor may use such non-deadly force as reasonably appears necessary to protect against imminent use of unlawful force, and here there is no duty to retreat. As you'll see throughout several of these defenses, this one looks at what is reasonably necessary. So the actor must believe that the force is necessary, and that force would be necessary to a reasonable person. Now let's go on and talk about the use of deadly force. This is where the defense is raised most of the time and where most of the action is in the area of self-defense. Okay, the first element is there must be a threat of actual or apparent force, and the actual or apparent must be deadly force. The threat must be unlawful and immediate or imminent. Sometimes you'll see the words unlawful, immediate, imminent, present. Basically the idea is to convey that the force that is coming upon the actor who is trying to defend themselves must occur at the moment. It can't be a threat of force later on in the future. The actor must reasonably and honestly believe that of the imminent peril of death or serious bodily harm, and must also have a reasonable and honest belief that the response they are about to engage in, the response that they are going to use, is necessary to save him from the threat, and that threat must be of actual or apparent deadly force. So as you can see here by the highlighted words, it's reasonable and honest. So this is both a subjective belief of imminent death or serious bodily harm and a subjective belief that it's necessary to use this force, and an objective belief. They must reasonably believe that the threat is of deadly force is needed, and they must reasonably believe that their response is necessary. Okay, there's a couple of special issues that we're going to talk about with regards to self-defense. The first one is the aggressor. As you will see from one of the cases that we're going to read, self-defense is not available to those who incite, encourage, or escalate the fatal quarrel, or otherwise promote the necessitous occasion. That is, the aggressor cannot rely on self-defense if they so injure or kill the person who they are opposing. However, there is opportunity for the aggressor to regain the right to self-defense, and they must show the initial aggressor must communicate the desire to withdraw and in good faith attempt to withdraw. So if the initial aggressor communicates this, takes some action to withdraw, and then the attacker keeps coming upon them, they can rely on self-defense in this situation. Okay. The other area that I want to talk about is this concept of retreat, and this has been controversial and has obviously been in the news in the last several years. The majority rule, the American rule, is that the non-aggressor has no duty to retreat. That is, the non-aggressor can stand their ground, and if they meet all of the elements for self-defense, they may defend themselves. The minority rule is that one has to retreat when they honestly believe that they can do so in complete safety. In most jurisdictions, this is a subjective, honest belief. that they can do so in safety. Now, there is an exception. The non-aggressor does not have to retreat from their dwelling. This is often referred to as the castle doctrine, that an aggressor does not have to retreat, a non-aggressor, excuse me, does not have to retreat from their home. Okay, let's take a look at how the Model Penal Code treats this. It treats it slightly differently, but not radically differently. Deadly force is only justifiable if the actor believes, and this is an honest belief, this is a subjective belief, that it is necessary to protect against death, serious bodily harm, kidnapping, or sexual intercourse compelled by force or threat. And the Model Penal Code does impose a duty of retreat. If the actor knows that he can avoid the necessity by retreating, they must do so. And again, there is an exception to retreating, and that is one does not have to retreat in their home. The home is obviously presumed to be a place of safety, and they're not going to require one to retreat from that. So this is not radically different than the common law, but it is a subjective belief. If you notice up above, the actor believes. This is a subjective belief. This is not an objective test. Okay, let's go on and talk about duress now. Duress is coupled in many instances, oftentimes in a discussion with necessity, which I'm going to refer to near the end of the discussion of duress. Okay, let's look at the elements of duress. Duress involves a present, imminent, or impending threat of death or grievous bodily injury unless the actor commits an offense. So this is obviously when one is relying on the defense of duress, they have been compelled by this threat to commit a criminal offense. And in this instance, the actor reasonably believes that the threat is genuine. Now again, notice reasonably believes. This is an objective, subjective test, and that there is no reasonable escape except through compliance with the demands, and the actor was not at fault in exposing herself to the threat. Okay, so we have these four elements come about in the defense of duress, and it's a defense when one is claimed that they were threatened or their family was threatened, and therefore they went about committing the criminal offense. There is an example in your casebook of a duress situation where a woman engages, or a man I believe it is, engages in the transport of drugs because he believes that his family has been threatened. Now, duress, as all cases will recite, is never, at common law, is never a defense to murder. Let's take a look now at the Model Penal Code version of duress. The actor is compelled, again there must be a threat being compelled, to commit the offense by the use of threatened use of unlawful force by the coercer upon her, that is the actor, or another person. So the threat can be against the actor themselves or another person, oftentimes a family member, close friend, or relative. That a person, and this is where the Model Penal Code gets into a rare occasion of putting in an objective test, that a person of reasonable firmness in her situation would have been unable to resist. So that's really the test. Was the threat such that a person of reasonable firmness in the defendant's situation would have been unable to resist the threat and therefore committed the crime? Under the Model Penal Code, there is no restriction to it being a defense of murder, although I can tell you most jurisdictions that have adopted the Model Penal Code test for duress still prohibit it as a defense for murder. Okay, let's take just a brief moment and look at necessity. Necessity is sort of like a brother or sister of duress and is oftentimes confused with duress, and you'll see it in the prison escape cases that the courts are confused as to whether to apply duress or necessity. Necessity generally is defined as due to natural forces, not human forces. So due to forces of nature, fire, storms, etc., creating a clear and imminent danger. The defendant reasonably believes that the conduct is necessary to avert the danger by conduct that is less serious than the harm to be avoided. The defendant did not substantially contribute to the danger in this situation. So what you see here is oftentimes the classic example is a fire is raging in the forest and the defendant burns someone's field of crops in order to prevent the fire from rushing through the field of crops and then burning down houses, the town, etc. And so you see, so the defendant has would claim the defense of necessity if they were charged with willful burning of someone's field, and they would claim that they relied on this defense when they burnt the field because they were trying to avoid a worse harm of the fire burning down some houses, injuring people, or burning down the town. Now, necessity, like duress, is never a defense to murder. Let's go on now. The third defense we're going to talk about is intoxication. And the one thing that you're going to see about intoxication is that there are various approaches. There is no one approach to intoxication. Jurisdictions have taken a variety of approaches, and today the most common approach is that it's not a defense at all. Many jurisdictions will have statutes that are similar to Ohio's that provide that intoxication is not a defense to criminal charges. Some jurisdictions still use the distinction between specific intent crimes, that it can be a defense to specific intent crimes, but not to general intent crimes, but only if it negates the specific intent element. So as we see, it could be a defense to larceny or burglary if it negates the intent to deprive, that in larceny, or the intent to commit a felony therein in burglary. But it would not be a defense to assault because assault is a general intent crime. Going on with the various approaches. Many jurisdictions will hold that it's not a defense to crimes that require malice, recklessness, negligence, or strict liability. However, it wouldn't be a defense then to common law murder because that is a crime that requires malice aforethought. But some do permit it as a defense to negate premeditation and deliberation for first-degree murder. But as you see, it's all over the place. There are various approaches. The final approach is the Model Penal Code. And the Model Penal Code, consistent with what it does in other situations, it's a defense if it negates an element of the offense. Generally, obviously, it would have to negate the element of culpability. So if it negates purposely or knowingly, so if the person voluntarily was intoxicated and intoxicated to the point that they did not formulate the purpose or was not aware, if not knowingly is the element, it could be a defense. Now the Model Penal Code does something interesting with recklessly. If due to intoxication the actor is unaware of the risk, which he would have been aware had he been sober, such unawareness is immaterial. Therefore, if the actor would have been aware of the risk had they not been intoxicated and the element is recklessly, it will not be a defense and will not negate that element of the offense. So you see here the jurisdictions are really all over the place with the defense of intoxication. Okay, we're going to talk about one last final defense here. And this defense is insanity. And for the first time, you really need to know this name, the McNaughton test. This is a test that was developed in the middle of the 19th century as a result of an assassination attempt on the Prime Minister. So let's go on and take a look at what the elements of the M'Naughton test, and this is the test that is still used in a significant number of jurisdictions in this country today. So the first part of the test is at the time of committing the criminal act. So the insanity has to be at the time of committing the criminal act, not later and not earlier. The accused was laboring under a defect of reason from a disease of the mind, and I'm going to talk about this in a minute, so as not to know the nature and quality of the act he was doing, and we'll talk about this again, or if he did know what he was doing, he did not know that what he was doing was wrong. Okay, so let's take a look at each of these elements. The accused was laboring under a defect of reason from a disease of the mind. Okay, this requires that at the time of committing the offense, the defendant was laboring under a mental disease. And, you know, these are significant mental disorders. They often require that it be psychosis, mental retardation, but most jurisdictions in their common law of insanity do not permit psychopathic or sociopathic disorders to qualify for such a disease of the mind. Okay, so as not to know the nature and quality of the act he was doing. And know here is complete awareness. One has to be completely unaware of what they are doing. And as I say, these are generally delusional or hallucinatory behaviors. They think they're squeezing an orange and it is someone's neck. They think they're shooting at a target, but it is a person instead. So you can see in each of these instances, the defendant completely is unaware of what they are doing and the harm that they are bringing about, the criminality of, or the action that makes their conduct criminal. Or he did not know that what he was doing was wrong. And now here, this time gets into an issue of whether they have to know morally that it was wrong or legally that it was wrong. And the jurisdictions vary. Some jurisdictions require that the defendant cannot know, because of their mental disease, that what they're doing is against the law. Other jurisdictions require that the defendant, just through the mental disorder, not believe that it is morally wrong. And again, it's a complete awareness. This is completely unaware that what they're doing is wrong. You know, and the example that often gets used is God directed to kill the other person because they are the devil. Well, in this situation, the defendant would not believe that killing the devil is both legally wrong or, in this instance, morally wrong as well. Okay, there are a number of jurisdictions that include an added test, and this is referred to as the irresistible impulse test. And this one is because of the mental illness or mental disease or defect of the mind, the defendant was unable to control his actions or to conform his conduct to the law. That is, through their mental disease, they could not control their behaviors and acted anyway. And oftentimes, this test will get referred to as the policeman at the elbow test. So if the defendant's mental disease caused the defendant to act, and the defendant would have done so even if a police had been present, if a policeman had been at their elbow, as it said, they would have committed their criminal conduct anyway, then they may qualify under the irresistible impulse test. Let's look at the Model Penal Code, because the Model Penal Code changes this in some significant ways. Okay, again, if at the time of such conduct, again, this isn't a change. Under all of the tests, the question is, was the defendant insane at the time they committed the criminal act, not whether they're insane at the time of trial or were insane earlier on. As a result of mental disease or defect, and again, this is very similar to what the common law was defining, but here more of a realization as to the current state of psychology and medical science. The defendant lacks substantial capacity to appreciate the criminality of his conduct, that is, lacks substantial capacity, you see here. It doesn't say no, which is complete awareness. It's substantial capacity to appreciate, to understand that what they were doing is criminal. In some jurisdictions, and the Model Penal Code has put in that it could be wrongfulness instead of criminality, but the generally prevalent test is criminality of its conduct. So the defendant didn't appreciate the criminality of conduct, or to conform his conduct to the requirements of law. This is really bringing in the irresistible impulse test into the Model Penal Code. Okay, that brings us to the conclusion of this series of videos and this presentation on defenses. Normally what I say at this point is that you need to go and fill out the assessment, but for this one, this is a freebie. There is not going to be an assessment because I expect that you may look at this tape in segments as we work our way through these various defenses. Thank you for paying attention, and this now concludes this video presentation.